Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-Immigration. I recently caught up with the folks at e-Immigration who shared a big announcement. Hot off the presses. Have you heard? E-Immigration is now integrated with the VisaLaw.ai. Over 10,000 users can now connect their e-immigration accounts to VisaLaw.ai, allowing them to generate expert letters, court documents, petition briefs, and entire case packets directly within their case management system. It's case management meets modern drafting, so you can build stronger cases faster than ever. The combination of e-immigration and VisaLaw.ai means what used to take hours can now be done in minutes. Just think how much faster your immigration workflows can be. Learn more at get.eimmigration.com/VisaLawAI, or of course, click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Hello, everybody. In some news, the district court lawsuit about DHS's illegal early termination of TPS for Haiti officially ended this week. The lawsuit brought by some exceptional plaintiffs and litigated by KKTP, Brian Cave, Just Futures Law, and Raymond Audain. In response to the win by these exceptional plaintiffs and this attorney team, USCIS finally updated their TPS page on Friday, and they did so as follows. I shall quote, alert. After reviewing country conditions and consulting with appropriate U.S. government agencies, DHS Secretary Noem determined that Haiti no longer meets the condition for its designation for TPS. Haiti's TPS designation and related benefits were slated to terminate on September 2, 2025. However, on July 15, 2025, a single judge in the U.S. District for the Eastern District of New York issued a final judgment in Haitian Evangelical Clergy Association v. Trump that makes the effective date of any termination no earlier than February 3, 2026. The judge did so even though the DHS secretary recently prevailed in the U.S. Supreme Court 8-1 in a similar case. The DHS secretary vehemently disagrees with this ruling and is working to determine next steps, end quote. As my partner Ed Ramos notes, the word similar is doing a lot of work in that DHS alert. And I must agree with my co-counsel's astute observations. I could be wrong, but I'm beginning to suspect that the current administration just really has no class. But I don't want to jump to any conclusions. Also, heads up, a bit tangential, so not going to do it this week, but if you're really on the weeds on drug trafficking in the 11th Circuit, give the court's United States v. Roe decision from July 15th a review. Seems like some things are changing for cocaine trafficking, at least in the sentence enhancement context. And also, looks like the Ninth Circuit issued a decision that will continue to prevent the Trump administration from bringing back the MPP, or Remain in Mexico program. Looks like a big decision issued late Friday night, which by now I'm sure you've read news articles about, and maybe have even seen in the context of a TikTok or two. Should I get on the platform? I'm taking votes. All right, enough blabbering on because we've got 7 cases, including some big important ones. Here we go. Our first case is Qatanani, the Attorney General of the United States, published by the Third Circuit on July 15, 2025. This case is about BIA self-certification of appeals of adjustment of status grants. Judge Mate dissented. The court starts off with some highbrow separation of powers stuff and states that, quote, when an administrative agency purports by regulation to evade procedures mandated by Congress and the INA, it is incumbent upon us to intervene, end quote. Gonna be a fun one, and it's gonna be a long one. Mr. Qatanani is a Palestinian born in the West Bank and grew up in Jordan, where he became an imam. He was, quote, detained, beaten, and interrogated by the Israeli military, end quote, in the West Bank in 1993. He's been in America since 1996, when he was admitted on H-1B visa and he applied to adjust to LPR status 3 years later. He works as an imam. In his adjustment of status application, Mr. Qatanani checked no to the question regarding whether he'd ever been arrested or imprisoned for violating a law or ordinance anywhere in the world. To paraphrase that question. Although unstated in this decision, there is little doubt to me that the U.S. government decided to subject Mr. Qatanani to the legally dubious post-9/11 CARP policy program, or whatever you want to call it, whereby USCIS was instructed to delay adjudication of naturalization and other applications filed by people who were usually Muslims, who the U.S. government couldn't prove were up to no good, but allegedly had suspicions of. Why else would Mr. Qatanani's green card application still be pending in 2005 when he filed it in 1999? And why else would the FBI show up when he inquired about the delay? During the interview, Mr. Qatanani disclosed that Israeli military had detained him in the West Bank in 2003. A year later, in the adjustment of status interview, USCIS showed Mr. Qatanani and his counsel the FBI officer's declaration. Seeing it for the first time, Mr. Qatanani's counsel objected and, by the way, asserted that it was inaccurate. USCIS denied the application, finding that Mr. Qatanani had committed fraud and willful misrepresentation in his adjustment of status application. Quote, relying on the FBI agent's declaration, USCIS found that in February 2005, in the interview, Mr. Qatanani admitted that he was arrested, pled guilty to a crime, and was imprisoned for 3 months by Israeli authorities in the West Bank in 1993, end quote. USCIS also denied adjustment of status as a matter of discretion. Then USCIS put him in removal proceedings. In a, quote, lengthy opinion, end quote, that followed a 4-day hearing, an immigration judge disagreed and granted Mr. Qatanani's adjustment of status application in 2008. By this point, DHS was also bringing material support of terrorism charges, which the IJ also rejected. So apparently an Israeli military court did indeed convict Mr. Qatanani way back when. Doing my math, it seems to be a court set up during the First Intifada. He was convicted of membership in Hamas and performing services for that entity, it appears. The IJ, however, noted that the alleged confession that Mr. Qatanani made in Israel that undergirded that conviction was not in DHS's conviction submission. Important because the IJ also found, quote, that the military court was internationally stigmatized for failing to meet fair trial standards, and even the Israeli Supreme Court had condemned it for abusive treatment to coerce confessions from detainees during the time of Mr. Qatanani's detention, end quote. Complicated world, no? Quote, the IJ also found it perplexing and remarkable that the Israeli military would convict Mr. Qatanani, who refused to cooperate or become a spy for Israel, of being a member of Hamas and then release him after 3 months and renew his West Bank residency permit, end quote. We're just getting started. At these first hearings, the FBI and the ICE agent also testified, and they said Mr. Qatanani admitted that he was arrested for being a Hamas member. Mr. Qatanani testified that he didn't say that. And the IJ believed Mr. Qatanani. Can you believe it? The IJ recounted numerous examples of the FBI agent being evasive, unresponsive, and contradictory. And Mr. Qatanani still had a misrepresentation problem though, right? Regardless of the merits, he was still arrested and convicted in Israel, and he didn't disclose it in the adjustment application. Well, no, to the IJ, what happened to Mr. Qatanani was an administrative detention, not a criminal arrest. Experts testified to this too. This had happened to thousands of Palestinian men in the territories in 1993, apparently. Quote, the IJ found that Mr. Qatanani reasonably believed that he was administratively detained without arrest in the West Bank in 1993, end quote. So no willful misrepresentation, it seems. And in any event, he voluntarily disclosed it to the FBI agent during that interview before USCIS adjudicated his application. Wow. I normally wouldn't go into this detail about an IJ's decision, but come on, guys. I've earned this, having dutifully accommodated the BIA's recent onslaught and all that cancellation hardship review post-Wilkinson from the circuits. So, noting Mr. Qatanani's, quote, outstanding character witnesses, end quote, the IJ granted adjustment as a matter of discretion. Quote, those witnesses included 3 law enforcement officers, 2 county sheriffs, and an assistant United States attorney who was the then chief of the criminal division of the U.S. Attorney's Office for the District of New Jersey, who testified to the assistance Mr. Qatanani provided to federal and local law enforcement during his tenure at the Islamic Center, end quote. Lots and lots of other stuff, too. Yet still, DHS appealed, and the BIA remanded, on some technicalities, it seems. The IJ then held 3 more hearings and granted the case again in 2020, making very clear the IJ's finding that Mr. Qatanani, quote, is not and has never been a member of Hamas, end quote. So 7 immigration court hearings in total. And while the BIA specifically remanded for the IJ to give the FBI and ICE agents another shot, quote, during those proceedings, DHS specifically refused to present the FBI and ICE agents to be rehabilitated, end quote. So, come on. True, the IJ did eventually find that a material misrepresentation had occurred in that first I-485, but because the overwhelming record evidence showed that Mr. Qatanani, quote, was tortured into making a confession of guilt, end quote, in Israel, he would have been admissible had he disclosed it to USCIS. So I guess it's not material. I think that's the analysis. Adjustment of status was again granted as a matter of discretion, notwithstanding a heated speech that Mr. Qatanani had then since given that was then played in court. And it was a bit of a heated speech that he gave after Mr. Trump recognized Jerusalem as the capital of Israel during the first Trump term. This time, DHS did not appeal, meaning the IJ's decision became final 30 days thereafter, which means Mr. Qatanani should have become an LPR. But USCIS didn't do it. Instead, 3 months later, DHS asked the BIA to accept a late-filed appeal. Quote, DHS filed its motion on August 12, 2020, and invoked a regulation that, according to DHS, permits the BIA to hear an appeal by certification in any case over which it has appellate jurisdiction, end quote. That's 8 CFR Section 1003.1c. DHS blamed COVID for the delay, even though I believe at the time the president was saying it was largely a hoax. Then the BIA accepted the appeal many months later, 11 months post-IJ decision, so 10 months after the 30-day deadline to appeal. Ironically enough, the first Trump administration took away the BIA's ability to self-certify, but notes the Third Circuit in a footnote, a district court enjoined the regulation the exact same day that the BIA self-certified this appeal. Then the BIA reversed the IJ on self-certified appeal and flat out ordered Mr. Qatanani removed to Jordan. All simply on discretion, which the BIA knows it can do de novo, hence why it probably chose that route. So an absolute mess to the Third Circuit, which is why perhaps Mr. Qatanani's very smart attorneys made a very smart argument. They argued that the BIA's self-certification in this case circumvented Congress's process for rescinding a grant of LPR status and the procedural protections afforded by that process. Because, right, Mr. Qatanani was technically an LPR as a matter of law on day 31, when DHS didn't appeal. The only way you can take away an LPR's status for past conduct like this would be rescission proceedings in immigration court. The Third Circuit agreed with the argument. The court begins by reminding Stephen Miller of the duty of, quote, the executive branch to faithfully execute the immigration policy adopted by Congress, end quote. Or maybe that's just me stealing their quote. Importantly here, when the IJ's grant of status adjustment becomes final, the Attorney General's discretion gives way to the INA's mandate that, quote, the Attorney General shall record the non-citizen's lawful admission for permanent residence as of the date of the order of the Attorney General's approving the application for adjustment of status, end quote. That's INA Section 245B. You never read that one, do you, everyone? But it's there. Giving adjustment of status after it's already been granted is not a discretionary thing. Shall is an important word, as used in the statute, and as the Supreme Court made quite clear in Boafa earlier this term, notes the Third Circuit majority. Well, what if USCIS drags its feet? Well, quote, although the recordation of an admission with LPR status is a ministerial task, one that helps track the number of LPRs admitted in a given year, the admission itself is a statutorily defined event, end quote. Remember that quote. Remember it, I say. And when that statutory event occurs, well, that gives the non-citizen all the privileges due of LPRs immediately, regardless of what USCIS has done on the back end. You hear me? And, quote, that status comes with a great measure of security, end quote, no matter how insecure the current administration is trying to make LPRs feel. Obviously, that latter part is me, not you, the court, but you know, guys, you know. One of the security benefits is clarity about how LPR status can be taken away, and the BIA violated that here, explains the majority. The rarely used rescission proceedings are statutorily defined things with serious burdens and requirements. The BIA totally circumvented that, and along with it, DHS's burdens, by self-certifying an untimely appeal of an adjustment grant. In making this holding, the Third Circuit majority batted down Oil's contrary arguments. Mr. Qatanani sufficiently argued this regulatory and due process-based argument before the BIA such that it's exhausted. And heck, as a due process claim, the BIA probably couldn't address it without finding it lacked jurisdiction over the appeal. So Mr. Qatanani didn't have to exhaust it anyway. You know I'm going deep, guys, but I'm having fun. The stakes are high, explains the court. Quote, the implications of this argument are extraordinary. Under this reading of agency authority, the government has carte blanche to evade the limits Congress imposed on the executive's discretionary authority over adjustments to LPR status and to circumvent the procedures Congress mandated for rescission of such adjustments. According to this view, by merely invoking two regulations, the BIA could render a final adjudication to LPR status non-final without the procedural protections that Congress provided. And it could do so at any time, end quote. As a last resort, quote, the government offers little more than its assurances that we can trust the BIA not to abuse its power. But trust us is a poor operating principle for government, end quote. Yes, it is. With such a constitutional violation readily apparent, it doesn't matter that adjustment of status is technically discretionary. Methinks me sees the ever so slight beginning of an argument there to get around Patel. Think about it. Not so much fleshed out in this decision, though. Nor does it matter that background checks may not have been completed or whether a visa was even available to Mr. Qatanani. Undiscussed in substance, and it smells fishy, this analysis, but anyway, that goes to whether the agency should have granted adjustment, not to whether it did to the court. I know it's been a really long decision, but such is this case, which concludes briefly by expressing, quote, our grave concerns, end quote, with the substance of that 2024 BIA decision. The Third Circuit notes that the BIA just ignored the IJ's facts, found facts, cherry-picked the record, and, quote, penalized Mr. Qatanani for quintessential First Amendment activity, end quote. That anti-Trump speech, I believe. How timely, Third Circuit. Meet the moment in dicta. Mr. Qatanani is an LPR. So mega, and surely MAGA, congratulations to David Isaacson and Cyrus Mehta, along with Molly Coe of the NYU Immigration Rights Clinic, and Claudia Slavinsky for petitioner. And that is Qatanani, the Attorney General of the United States. We got multiple from the BIA now. What else is new? First one is a matter of CMM, published by the BIA. It's another case about bond that the Attorney General has found and decided to make precedential after being non-precedential. If you haven't noticed the pattern, the Attorney General, or her nameless investigator of all things BIA, is quite concerned about incarcerating non-citizens and denying them Convention Against Torture protection. An IJ granted Ms. CAM a $15,000 bond. DHS was not pleased and appealed. The BIA reversed, and now it's precedential. Ms. CMM is a danger reason to the BIA. DHS actually had the burden here based on a continued class action in the Central District of California, which is very unique, rock on Central District of California. And yet still the BIA believes that DHS met its burden by clear and convincing evidence. Ms. CM pled guilty to aggravated assault causing serious physical injury under Arizona law, and the criminal court ordered her to serve 7 months in county jail with credit for time served. She was also sentenced to supervised probation for a term of 4 years after her release, with an order to have no contact with the victim. Now, the IJ reasoned that Ms. CMM wasn't sentenced to a term of imprisonment. That was wrong to the BIA, given what I just said above. The IJ was also wrong to the BIA to hold that Ms. CMM, quote, was attempting to act in self-defense, albeit imperfectly, end quote. To the BIA, and even in the bond context, quote, it is well established that neither an IJ nor the BIA may look behind the fact of conviction and relitigate the ultimate question of a non-citizen's guilt or innocence, end quote. Conviction and plea agreement and nothing more for the IJs. It was a recent conviction, though, explains the BIA, and here we go. Ms. CM poured alcohol on her partner's back and set him on fire with a cigarette, severely injuring him. And Ms. CMM has a lengthy criminal history as well. Nor does the BIA think that Ms. CMM has taken responsibility, notwithstanding her post-release plan and promise to stay away from the victim. The BIA also deemed Ms. CMM an irredeemable flight risk, given her 5 unlawful entries since 2001, 2 illegal reentry convictions, and in at least 1 incident, her attempt to use her daughter's U.S. citizen birth certificate to enter the U.S. Finally, explains the BIA, but Ms. CMM is currently in withholding-only proceedings. Surely, given the reinstatement of her final order of removal, and explains to the BIA, quote, for various reasons, eligibility for fear-based relief can be difficult to establish, end quote. Given all of that, the BIA reversed the grant of bond, finding DHS had met its burden. Some thoughts. I don't know. Maybe Miss CMM should not be granted bond. Maybe. Certainly seems that she has tragic mental health issues and has had a rough life. But her case does seem extreme and very different from the average bond seeker. My gripe, and yes, if you haven't noticed it, I have a gripe, is that the Attorney General is finding extreme BIA cases to make precedential so as to issue expansive holdings chock full of quotes that IJs will apply in non-extreme cases. That seems to be one reason that the Attorney General is identifying these cases for publication in the first place, as her agency simultaneously fires IJs, making it quite clear to the remaining IJs that they're expected to read between the lines of what the BIA is publishing on the Attorney General's orders. Why else make extreme cases precedential? And well, that's not what I learned case law was supposed to be for. And that is a matter of CMM. If you thought that one was rough for the non-citizen bar, wait till you hear this one. Matter of KESG, published on Friday by the BIA. This case, well, it's a gut punch. It's about nationality and sex-based asylum claims. And it follows a Sixth Circuit remand on Oil's own request. Herein, stating that it was applying matter of ARCG, the BIA found that Miss KESG's asserted particular social groups of Salvadoran women and Salvadoran women viewed as property are not cognizable under immigration law. Allow me to explain. Quoting the Third Circuit, the BIA begins by stating, quote, read in the broadest literal sense, the phrase particular social group is almost completely open-ended, end quote. What a quote. The BIA has therefore embarked on a decades-long quest to narrow the broad phrase adopted by Congress. Today, of course, a particular social group must 1. Be composed of members who share a common immutable characteristic, 2. Be defined with particularity, and 3. Be socially distinct within the society in question. Particularity and social distinction overlap a bit, explains the BIA. To be particular, the group, quote, must be discrete and have definable boundaries. It must not be amorphous, overbroad, diffuse, or subjective, end quote. Citing to matter of WGR and in direct violation of Fourth Circuit precedents, I believe, the BIA states that, quote, as part of the particularity requirement, societal considerations will necessarily play a factor in determining whether the group is discrete or amorphous, end quote. Applying these principles, the BIA first addresses sex in the least fun way possible. Yes, sex, such as being a woman, is immutable, explains the BIA. But more is required to satisfy particularity. Famously, the Ninth Circuit seemed to indicate that sex could satisfy the particular social group requirement in its 2010 Perdomo decision. So too, the First Circuit got close into Peña-Paniagua v. Barr from 2020, explains the BIA. But to the BIA, quote, the Ninth Circuit's decision in Perdomo was based on a prior definition of a particular social group, end quote. I must say that I disagree with that. I've always understood matter of MEVG and WGR to be clarifying rather than changing the particular social group definitions, but what do I know? Since that time, of course, the Ninth Circuit has endorsed the BIA's 3-part explanation from MEVG, although I'm not sure that it has done so since Loper-Bright. The BIA goes on to attack Perdomo for a bit. It also explains how other circuits have rejected purely sex-based particular social group claims. Having conducted this overview, the BIA holds that, quote, sex, or sex and nationality, standing alone, is overbroad and insufficiently particular, end quote, to be a particular social group. How to narrow it sufficiently? Well, the BIA mentions, quote, a specific age range or a specific position in the country's society or its economy, end quote. In a footnote, the BIA also mentions 7th and 8th Circuit decisions that have added characteristics of, quote, women from a minority religion who have lived alone or widows, end quote, respectively. Were the BIA to hold otherwise, it believes that it would essentially be creating a 6th particular social group. And it can't do that. Indeed, in going all the way back to the 1954 convention, quote, it would have been an obvious choice to have included sex as one of the expressly enumerated grounds for persecution if sex alone was intended to form a basis for protection, end quote. The BIA actually relies on this logic quite significantly to support its conclusion. I wonder how the circuits will view it. Applied here, then, that wrecks the first particular social group, based on Salvadoran nationality and women. That there's laws to specifically protect women in El Salvador is not important to the BIA. It is for social distinction, though, flat out, that's black-letter law. But nor does the BIA care about the unpublished BIA decisions that Ms. KESG submitted in support. A circuit might, though. But in any event, quote, that certain characteristics may make individuals more vulnerable to violence does not establish that individuals sharing that characteristic necessarily constitute a cognizable particular social group, end quote. As to the other group that adds the phrase, quote, women viewed as property, end quote, to the Salvadoran women, well, the BIA doesn't believe that particular either. Quote, the respondent has not presented evidence that viewed as property is a commonly accepted definition in El Salvador, end quote. Again, that is a concern that, at least in the Fourth Circuit, would not likely be relevant to particularity, but it would for social distinction. The BIA believes it relevant for both. As applied here, though, the BIA doesn't know who is and who is out of the proposed group, making it not particular. But the BIA did remand on Ms. KESG's motion to permit her to apply for non-LPR cancellation of removal. It's a motion to remand and not a motion to reopen that, explains the BIA, because the Sixth Circuit's remand made the BIA's prior removal order that was final non-final, which in turn means that the number and time limitations usually applicable to motions to reopen don't apply. It's just a motion to remand. Remember that. While the standard might be similar for a motion to remand and motion to reopen, filing a motion to remand while a BIA appeal is pending is materially easier to win then, as compared to waiting for the BIA to rule and filing a motion to reopen, even if it's the same arguments. Anyway, that was a bit of a tangent. Without helpfully explaining what evidence she submitted, the BIA states summarily that Ms. KESG, quote, has submitted an application for cancellation of removal together with sufficient evidence to establish that she meets the prima facie eligibility requirements for cancellation of removal, end quote. So while great for Ms. KESG, it will of course provide the BIA the benefit of not having this decision immediately reviewed by the Sixth Circuit, and so it will remain precedential for many years without really being attacked, at least on direct petition for review. Don't tell me the BIA is not strategic. Final thoughts. Look, I disagree with this decision, but that's okay. That's the beauty of our profession, I suppose. As I have the mic, my opinion is being stated. I think that if we're being intellectually consistent, sex or gender is of course a particular social group, and that the true battle for granting or denying such claims should be in the realm of nexus. And that battle will often be lost for asylum seekers. But that's where the battle should be, if we're being intellectually honest. This decision is unfortunate. And that is a matter of KESG. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez Immigration Bonds take it from there. They help families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process, and they typically issue refunds within 1 to 2 weeks of receiving the I-391 bond cancellation notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your client stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40, and for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They got those too. They're family-owned and have been in business for 75 years. Gonzalez & Gonzalez Immigration Bonds. Efficient, supportive, and trusted. Visit immigrationbond.com, click on the link in the show notes, or call at 833-409-9200. Are you fighting like a maniac, completely overwhelmed by the chaos of the new administration? Immigration policies are shifting fast, the pressure is piling up, and clients are desperate for help. You're working around the clock, but there's only one of you. Well, Staffy's got your back. Staffy's bilingual virtual paralegals and administrative assistants handle USCIS forms, client intake, evidence gathering, and scheduling, so you're not drowning in paperwork while trying to fight for your clients at the same time. Stop running on empty. Staffy gets you a trained, ready-to-go team fast with HR-backed support, onboarding, and continuous training. You don't have time to do it all alone, and you don't have to. Schedule a consultation at staffy.cc, that's stafi.cc, and claim $500 off your first month. Welcome back. With Mejia-Hernandez v. Bondi, published by the 7th Circuit on July 17th, 2025. This case is about nexus. Miss Mejia is from Honduras. Her uncle killed a man in 1995. That man's son Kisor began to seek revenge in 2006, eventually killing 6 of the uncle's family members, which of course are in Miss Mejia's family, too. Kisor started with the grandfather at a bus station. Pardon my language, a witness heard Caesar yell, quote, "I am going to finish off all of these sons of bitches, all these dogs. I'm going to kill all of them, these pieces of garbage. None of them is going to remain," end quote. Despite this and some scary threats to Miss Mejia and the family in writing, the family reported Caesar to police and he was imprisoned for 4 years. Released in 2010, though, Caesar began threatening to kill the other family members for reporting him, and he followed through. He went on to murder the grandfather's nephew and 4 of Miss Mejia's cousins, including all the way up to 2017. A 5th was shot but survived. Witnesses were quite clear that Caesar and his brother said that they're trying to finish off the entire family. But the family didn't report that suspicions that Caesar was behind these later killings, given their belief that police actually were aligned with Caesar's family and that Caesar's government connections had helped him get out of prison after only 4 years the first time. After learning from a bus driver that an armed man was looking for her, Miss Mejia fled the United States in 2018 with her children. An IJ and then the BIA denied Miss Mejia's asylum claim. Rather than harm on account of a protected ground like family membership, the agency saw this as, quote, "revenge based on a personal dispute," end quote. Just crime, albeit horrific crime. Nor did the agency believe that Miss Mejia had suffered harm rising to the level of past persecution or that she had a well-founded fear of future harm. The Seventh Circuit could not agree. First, it does believe that her experience in Honduras rose to the level of past persecution. The year's worth of credible threats against Miss Mejia and her family meet it, explains the Seventh Circuit, at least when considered as a whole. Caesar, after all, acted on his threats, unlike in other Seventh Circuit cases that have found no past persecution with threats. Although, that is not required, that is, killing 6 members of the family. And that is no small holding, that is, that these threats can be past persecution. It should mean then that DHS has the burden to rebut, provided, of course, that the past persecution is on account of a protected ground, the nexus requirement. After mentioning that, but before getting to it, the Seventh Circuit held, in the alternative, that even without past persecution, it sees a well-founded fear claim. Quote, "The continuous threats and actual violence toward Miss Mejia's family establish that her fear of future persecution is reasonable," end quote. I would think so. This explained the court, even though the grandfather was murdered nearly 20 years ago. Because in the years that followed, 5 members were killed and another was shot, going all the way up to almost when Miss Mejia fled. The family that remained had to flee to another town. Now again, assuming no past persecution, Miss Mejia would then have the burden to show that she couldn't reasonably relocate, and some of her family have literally relocated in Honduras, so that might be a problem here. Not so, explained the court, given that Caesar tracked the grandfather, for example, to a town 4 hours away. Similar with one of the cousins. And Miss Mejia herself tried to relocate, but she still received threats. Similarly with her parents. So relocation satisfied to the Seventh Circuit. All that to say, Miss Mejia probably doesn't have the burden anyway, right? Because the harm she suffered rises to the level of past persecution, again, assuming a nexus, which the Seventh Circuit believed was present. On this, the Seventh Circuit cites to its 2018 decision, WGA v. Sessions, which predates the pod, but if I remember the case correctly, is a banger and definitely something to rely on in the Seventh Circuit. Here, Caesar and his accomplices, quote, repeatedly targeted Miss Mejia's entire family because of their relationship to the uncle and grandfather. And as in other precedent, Miss Mejia would not have received threats were she not related to her uncle and grandfather. Her family relationships were the reason she, and not another individual in Honduras, was targeted by Caesar, end quote. Nexus satisfied, and don't forget that last phrase. This is strengthened, explains the Seventh Circuit, by the fact that Miss Mejia was not in any quarrel herself with Caesar. He had no reason personal to Miss Mejia to target her. Strongly supports a family-based nexus finding, as other circuits have similarly reasoned. I could be wrong, but the Seventh Circuit seems to be saying that the agency is wrong to deny family-based asylum claims like this as simply, quote, revenge based on a personal dispute, end quote. Seems like this is quite the decision to rely on to attack such BIA denials. The final element needed for past persecution, though, was the Honduran government unable or unwilling to protect Ms. Mejia. Well, the IJ apparently didn't conduct adequate findings there, so it was sent back. A pretty important open issue then, but there are many facts supporting Ms. Mejia's claim, I'd think. I mean, the guy got 4 years for murder in broad daylight, and not even on Fifth Avenue. The case was therefore remanded in a big way. Congrats to counsel, unnamed because the Seventh Circuit doesn't do so in its day of opinions. And worth mentioning. Here, the court also held that the agency properly rejected Ms. Mejia's objections to the deficient notice to appear that initiated this case because the objection was untimely. No minor holding from the Seventh Circuit, which at one point kind of was leading the way on deficient NTA objections. It appears here that, likely due to case law changes in the interim, Ms. Mejia didn't assert DHS's claims processing rule violation from the NTA until the merits hearing below. So this decision stands for the proposition that that's an untimely assertion of a mandatory claims processing rule in the Seventh Circuit. Of note. Boring way to end that one, right? And that is Mejia-Hernandez v. Bondi. Sticking with the Seventh Circuit, we have Singh v. Bondi, published by the 7th on July 18th, 2025. This case is about the BIA reissuing its decisions. Mr. Singh is a Sikh from India who alleged that he and his family had suffered repeated violence for over half a decade due to his work and membership in the Man Party. An IJ found Mr. Singh credible but didn't believe his experience bad enough. And he believed that he could relocate within India to avoid the harms he had suffered and feared. The BIA affirmed on September 12, 2018, meaning if he wanted circuit review, he needed to petition for review 30 days thereafter. However, Mr. Singh's attorney at the time apparently didn't have the resources to file a petition for review, explains the Seventh Circuit. So Mr. Singh retained an attorney recommended to him by a friend. But that attorney wasn't admitted before the Seventh Circuit and didn't tell Mr. Singh that. That's a pretty big problem. That attorney had Mr. Singh print and sign the petition for review, which doesn't make sense to me because that's not needed for a petition for review. Then the attorney mailed it to the Seventh Circuit. All timely, actually. But for reasons unexplained, the mail carrier didn't deliver the petition for review to the Seventh Circuit for 13 days. By the time the mail carrier did, the petition for review was untimely. So Oil moved to dismiss the petition for review, and the Seventh Circuit granted the motion. To be honest with you, I'm not sure how an attorney not admitted to the Seventh Circuit could have filed a petition for review anyway. Within days, a new attorney with the same firm came aboard and moved the BIA to reissue its decision so Mr. Singh could petition for review that decision. The BIA denied that. 2 months later, Mr. Singh filed a motion to reconsider, which he later clarified was a motion to reopen, this time alleging ineffective assistance of counsel. And if I recall, the Ninth Circuit held that such a motion was viable just a few weeks ago. The BIA denied that motion 2 years later. Mr. Singh then petitioned for review that to the Seventh Circuit. Oil actually didn't love the BIA's ineffective assistance analysis, so moved for a remand, which was granted, but now it's all back to the Seventh Circuit. It does seem like even the BIA assumed on remand that such an ineffective assistance of counsel motion was viable, even though the ineffective assistance pertained to the petition for review. The Seventh Circuit affirmed the denial. Because at a minimum, explains the court, Mr. Singh did not comply with matter of Lazada, a strict procedural test for ineffective assistance of counsel claims found nowhere else in law. One of those Lazada requirements, explains the Seventh Circuit, is, quote, establishing a detailed attorney-client agreement and the subsequent deficiencies, end quote. And I see, I get it. Big problem here, quote, not only does Mr. Singh acknowledge that there was no contract, oral or written, he also fails to allege what exactly he retained the attorney to do. That shortcoming is important because the assertions in his affidavit are entirely consistent with an agreement that the attorney's firm go straight and file a pro se petition for review, which is what it did, end quote. Wildly unethical, right? That's a whole nother issue. And it's a bigger problem for a Lozada claim, which requires proof of the scope of work agreed to and allegedly then performed deficiently. And then, of course, you've got Lozada's requirement of filing, quote, a complaint with the governing disciplinary authorities or explain why the movement has not done so, end quote. The bar complaint requirement that has resulted in good immigration attorneys leaving the practice and, in extreme cases, ending their own lives. Not all circuits strictly mandate this requirement, and it looks like Mr. Singh actually filed a disciplinary complaint. But that alone is not sufficient, explains the court. Lozada also requires that a non-citizen notify prior counsel and give them an opportunity to explain and include that explanation in the ineffective assistance of counsel filing. Which is true, Lozada does require that. Doesn't look like Mr. Singh did this. So, the Seventh Circuit denied the petition for review, which had asked the BIA to reissue the decision, so Mr. Singh could petition for review. And that is Singh v. Bondi. I decree that we will conclude with two from the First Circuit. The first is Goncalves Leal v. Bondi, published by the First Circuit on July 14, 2025. This case is about exceptional, extreme, and unusual hardship. Mr. Goncalves is from Brazil. He had a, quote, brief relationship, end quote, with a woman in Brazil in 2001. Unbeknownst to him, she became pregnant and moved to the United States. He learned at some point, end quote, motivated by a desire to be with his son, end quote, Mr. Goncalves moved here too in 2004, entering the U.S. without authorization. ICE now takes the position nearly 30 years after the passage of IRIRA, and indeed, for the first time in U.S. history, if I'm not mistaken, that people like Mr. Goncalves are subject to mandatory detention without even the opportunity to apply for a bond, even if they're not dangerous or a flight risk. But that is not the appropriate interpretation of the law, nor was it the policy back then or at the time of these removal proceedings, so Mr. Goncalves has in large part remained not detained, posing no risk to anyone, and saving the U.S. government hundreds of dollars per day in detention costs throughout the course of these many years of proceedings. Anyway, for the last 21 years, Mr. Goncalves has been living near his U.S. citizen son, and he's gotten to raise him. Based on his U.S. citizen son, Mr. Goncalves applied for non-LPR cancellation in removal proceedings. The son, however, was already 17 years old by the time of the merits hearing. Still well under the age of 21 as required to qualify for that relief, to be a qualifying relative, that is, but we're getting close, right? The IJ deemed the asserted hardship insufficient to grant relief anyway. Mr. Goncalves' counsel asserted that, quote, this case was about a rebellious teenager spiraling out of control and in need of his father, end quote. And the evidence does seem to support this. But at the IJ, and to summarize, the child still had his mother, and these things aren't beyond those expected of a father's removal. Seems like a bit of a close case, though, given how the IJ ruled and the serious issues Mr. Goncalves' young adult son was having at the time. By the way, it does seem that ICE briefly detained Mr. Goncalves in this case, and that is what began the complete downward spiral of his U.S. citizen son. Just 2 months of detention. Just mentioning, no reason. The matter spent many years on appeal at the BIA, nearly 5 in fact. That made the son 22 years old, and so the BIA said, sorry, you're not eligible for cancellation anymore, because our delay caused your son to age out, meaning that you no longer have a qualifying relative. To paraphrase the BIA. In the alternative, the BIA affirmed the IJ's insufficient hardship finding. And that is what the First Circuit affirmed. First, the standard of review post-Wilkinson. The First Circuit says it's, quote, deferential, end quote, but doesn't explain further. I'm sure guidance will be forthcoming in a later decision. The court then summarily rejected the argument that the BIA's decision was fatally flawed because it apparently does not spell out the standard of review. To the court, the BIA applied the correct standard to the factual and legal disputes, respectively. On to the law, then. Like many courts before it, the First Circuit saw the BIA's decision in the matter of Monreal Aguinaga from 2001 as the seminal hardship case, laying out factors for IJs to consider. That includes the age of the qualifying family member, the family ties, length of residency in the country, the health of the petitioner and qualifying family members, the political and economic conditions in the country of return, the possibility of other means of adjusting status, the non-citizen's involvement and position in his or her community, and the non-citizen's immigration history. All of it has to be considered in the aggregate and on a case-by-case basis, and those are just example factors. Here, the BIA cited Monreal, and while it didn't discuss every factor, it need not explain the First Circuit. Particularly when Mr. Goncalves didn't explain, apparently, how the non-discussed factors help his case. The court also believes that the BIA considered all evidence, particularly, again, as Mr. Goncalves apparently didn't really explain the important evidence that he believed the agency missed. Nor did the First Circuit did the BIA create a new rule by noting the lack of expert medical evidence present in this case. It has long been the case that, quote, if the record lacks expert confirmation of a claimed medical condition, the petitioner may have more difficulty proving the severity of the relative's medical issues, end quote. And that's probably the case with country condition experts, too, on asylum. Removal defense is getting expensive. That's a big deal, too, with hardship review, right? Because you can't dispute facts at the circuit level, including how bad the medical issue is to your qualifying relative. Gotta make your record below. The rules are harsh. On to the final challenge, then, whether Mr. Goncalves had established sufficient hardship, considering all the facts found by the IJ. To the court, the standard requires, quote, truly exceptional, end quote, hardship to a qualifying relative. That the son is in a rough spot is not disputed, explains the First Circuit. But the question of the court is whether Mr. Goncalves' removal would move the needle on the son's condition such that the hardship would become exceptional and extremely unusual. And here, court does not seem to see it, given that he'll have his mom, he'll have therapy, and that he didn't apparently live with Mr. Goncalves in the past anyway. Mr. Goncalves, quote, admitted that his son did not heed parental guidance and refused to accept available treatment, despite Mr. Goncalves' proximity to and regular contact with his son. And aside from Mr. Goncalves' conjecture, there was no evidence to show that his son's poor decisions would subside if the agency granted Mr. Goncalves' application for cancellation of removal, end quote. And so, particularly given the deferential review of such things, the First Circuit affirmed the agency. And that is Goncalves-Leal v. Bondi. Our final case is Att'y v. Bondi, published by the First Circuit on July 16, 2025. This is another First Circuit decision about exceptional and extremely unusual hardship review. And it's a short one, to end a long and heady episode. Miss Att'y is from Guatemala and has lived in America since 2013. In pertinent part, she applied for non-LPR cancellation of removal based on the hardship her removal will cause to at least one of her 2 U.S. citizen children. The children seem great, are doing well, and the eldest seems to want to go into the Army and become an engineer. One of the reasons that the IJ denied it seems was based on the finding that the children would stay behind if Miss Att'y was removed and live with their father, who it appears also lacks status, but is not in removal proceedings. Kinda odd, all that. And can I just note, if President Trump's executive order on birthright citizenship is going to go into effect in some places, even temporarily, what is that going to do to cases like this, where the qualifying relatives are the U.S. citizen children of 2 parents who were not born in this country and don't have status and are applying for cancellation of removal? Is that going to just destroy all of these type of cases, at least for a short period of time, and such that these people can't get relief in immigration court, which is clearly at odds with the INA? Something no one's talking about because it is very tangential to the big issue of birthright citizenship, but, doesn't that just show how wrong the executive order is? I digress. In this case, while the U.S. citizen children would have some hardship without their mother, reasoned the IJ and BIA, it wasn't bad enough. The First Circuit affirmed again. After all, it reasoned, quote, "This aspect of the standard accords with the fact that the hardships typically felt by children whose parents are removed from the country represent a type of hardship that itself sets a high bar," end quote. Restated Congress wants this and sanctioned the separation of families absent pretty extreme hardship showings. The First Circuit rejected Ms. Ali's challenges. It does not believe that the agency ignored evidence, particularly as some of the alleged evidence ignored pertained to non-qualifying relative family members. Nor is hardship to an applicant herself overly relevant unless it also shows hardship to a qualifying relative, even if, for example, Ms. Ali suffers from arthritis. Quote, "True. Ms. Ali questions how the children will be affected by the knowledge that their mother is now living in an indisputably dangerous environment," end quote. That is Guatemala. And the First Circuit actually seems somewhat sympathetic to this argument. It just doesn't see record evidence to support it. But with evidence, it seems like a viable factor in a cancellation case in the First Circuit. Nor to the First Circuit did the agency fail to undertake an individualized analysis in this case. Rather, explains the court, the agency did discuss facts specific to the children, even if it did so alongside the usual stuff that the BIA always says in hardship denials. Like this, quote, "Such losses, while regrettable, are by no means exceptional or extremely unusual for non-citizens who have close family members who are removed," end quote. The BIA said it was, quote, "highly sympathetic," end quote, and the First Circuit credits that statement. Seeing no reversible error, the court denied the petition for review. And that is Ali v. Bondi. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzelli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.